even if you do have a doctor's opinion or you're getting everything on the record, if a judge properly discredits it within their ALJ written decision, and some of those decisions are 24 pages long, or give or take, if they really go through and properly discredit it, even though we may strongly disagree with the judge's opinion, and we strongly think and believe our client is disabled, there may not be enough legal error to pursue the case in federal court. Welcome to the Evans Disability Podcast. We hope to be your definitive guide through the Social Security Administration landscape. I'm Peter Evans, your host and managing partner at Evans Disability, a law firm that handles disability cases throughout the United States. Before we dive into today's episode, I want to mention a special resource for our listeners. Click the link below to receive a free SSA disability guide from Evans Disability. This guide is packed with details on SSA disability programs, expert tips for winning your case, and sample questions from actual disability hearings. Join me as I sit down with special guests, including experienced lawyers, our extremely well-trained staff, and even a former Social Security law judge. If you find our content useful, please hit the like button and don't forget to subscribe to stay updated on our latest discussions. I hope you enjoyed today's episode. Good morning, Isabella Baez. How are you?
I'm good. How are you, Peter?
I'm good. Well, welcome back. I want to, just by a quick introduction, your name is Isabella Baez. You are an attorney at Evans Disability. And I'm going to go link that bio interview that we did. I don't know how long ago. It's been probably several months at this point. But I'll link that in the description so people can get to know you better. But just quickly, you're an attorney in our firm. You've done multiple hearings for Social Security clients at the administrative level, graduated from University of North Carolina Law School, and then, but your primary focus is helping to serve clients at United States District Court level, and just really kind of going through that process outside of the Social Security Administration, but through United States District Court.
Right. Yeah.
So before we dive in, and because today I want to kind of ask you just sort of big picture, the process of federal court, how lawyers get paid, possible outcomes, things you're looking for. But what I really want to distinguish for our listeners is that when you start a Social Security disability claim, you start it within the Social Security Administration. And the Social Security Administration is a federal program that is designed for people who are retired, people who are disabled, sometimes survivors benefits like dependents, widows, widowers. But our primary focus is the kind of the disability programs within Social Security. And so when people first apply, it's not a state program. A lot of times people think, oh, well, I got mail from the state of Texas or Oregon or California. But it's really a United States federal program. And they do get mail from the state of Oregon and, wherever they may live or even outside of where they live. Because the Social Security Administration does use local help in helping decide these cases. But big picture-wise, it's a federal program. And when they apply, there's the application process. They go through that. And if they're denied, which right now we're seeing on average is about 7 to 8 months it takes to get through the application. And if they're denied, they can request an appeal. And that first appeal is called a request for reconsideration. And on average, that takes about another, 6-7 months. And if they're denied there, they can request a hearing before an administrative law judge. And these aren't your local city judges or your local county judges that and the reason I'm bringing this up, sometimes clients will say, oh, the local judge knows me really well and he's going to definitely give me benefits. That's not your local judge's job to do federal Social Security cases, it's actually a very specific judge that all they do is Social Security disability cases. I guess every once in a while they'll do a Medicare or Medicaid case, but all they do typically is Social Security disability cases. And so then they go to the hearing, and then if they win, great. And and people can win along the way, but if they lose, then they have to file another appeal, and that's called a request for review of my hearing decision, and that goes to the appeals council. And at the appeals council, that's about a 12-month wait. So it's sort of, that is the appeals council is the final appeal within the Social Security Administration, right? So I think of it as, a big box grocery store like a Walmart or, Target, where within Target, you have these kind of 4 different lanes that you have to go through. But once you've gone through all 4, if you've been denied all the way through, you've exhausted all your appeals within the Social Security Administration. And then what happens is the appeals council, and this is really important to note, they give you 60 days. Well, and technically it's 65 because they give you an additional 5 days for mailing. But so 65 days to file in United States District Court. And the reason I want to give the background to that is because most lawyers, not most, but a lot of lawyers do not take their clients to United States District Court. It's a whole different ball of wax. And United States District Court, you do need to be licensed as an attorney. You do need to be licensed in the state that your client lives in. Or you can get a special request to file cases in other states with local counsel, right? But it's a whole separate case in United States District Court. At least that's how I view it. So you've left Walmart or Target, and now you're going into a different store. It's literally like leaving that grocery store and walking into a different grocery store. And then in that federal court system, they don't just do Social Security cases. In fact, we just released a podcast with a dear friend of mine, Shannon Gray, who talked about United States District Court and the criminal cases that he defends in the United States District Court. And there's also big civil lawsuits that go on in the United States District Court. It's not your local county court or your city court or your municipal court. It's federal court. So after leaving kind of the Social Security Administration and that box, then we make a decision as a firm whether to go to United States District Court. And so that's what I want to talk to you about today, and just giving that background. Obviously, you know all this, but giving that background for our listeners. So let's start with a claimant has been denied at the Appeals Council, and we're trying to make a decision on whether they should go to United States District Court, or you're looking at kind of what are you looking at and what are you looking for?
Sure. So you're exactly right. Once you've been denied at the Appeals Council, basically what you'll have usually is a decision from an administrative law judge. And what we do as a team of attorneys is basically look at that decision, see what they use to decide whether your case was persuasive or not. And that includes evidence, including medical opinions, your own symptom testimony. If you guys remember all of those forms that you filled out at the very beginning of your application, things like that. That's part of your symptom testimony. We're looking at things like if you're a veteran, your VA records. We're looking at third-party reports. Basically, what the attorneys do to see whether your case is viable for a good appeal to federal court is whether this administrative law judge made any mistakes, which are called legal errors, in finding that, in fact, your case wasn't persuasive for disability. So there are a few common ones that we look for, and I can go into those if you'd like, Peter.
Yeah, why don't you give us our top 3 or 4 common ones that you look for? I know there's a pretty long list, but why don't we just start with why don't we just talk about the common ones?
Sure. So the biggest one that I see in a lot of cases is where an administrative law judge will not properly evaluate a medical opinion, either if that's from, your PCP, if that's from one of the state agency consultants that you did one of your examinations with earlier on in the process, or a consultative examination from Social Security doctors as well. That's one huge legal error that is really, really common, is that an administrative law judge will say, oh, I don't believe this particular opinion, which is supportive of your disability. They'll say, I don't think it's persuasive, one, because it's not supported internally, which means that basically the doctor didn't give enough explanation to why they believed, for say, you can only sit for 2 hours out of an 8-hour day, or why you can only concentrate for 20% of the day, or something like that. So an administrative law judge, is required to give a proper analysis and a proper evaluation under federal law that requires them to kind of really fully explain themselves and why, one, it was supported internally, and then two, is the actual opinion consistent with the longitude of your record? So they also have to explain, okay, does this particular doctor's opinion kind of go along with the rest of your record? Is it consistent with all of your other doctor's notes from other places, kind of your subjective complaints as well? So that's one of the biggest common legal errors that I do see.
Yeah, and before we jump to the second one, let's talk a little bit about, or at least what I'd like to say to our audience is, it's really important that if you can, and you do have a supportive doctor, if you can get them to write a letter or fill out a physical residual functional capacity questionnaire, or tell your lawyer that you have a supportive doctor, and most lawyers who do what we do have those type of questionnaires or have instructions on how to write a proper letter that can be supportive in your case. And that if you get those in and the ALJ, the Social Security judge, denies you, it can still be really instrumental and important later in an appeals case. What's the second thing that you look for?
The second thing that I look for is really having to do with your own symptom testimony. So basically everything that you're telling a Social Security about your symptoms, about your diagnoses, and whether the judge thinks you're credible or not. And it all kind of goes to the law as well here, and whether the judge evaluates it properly. And one of the things that they actually have to do under the law is provide clear and convincing evidence of why or why not that they think that your alleged symptoms, and when I say alleged symptoms, I mean a lot of judges find that with your diagnoses and conditions, of course, they can bring about certain symptoms, like for degenerative disc disease, for example. Of course, they're going to create some back pain here and there. The judge isn't saying that you're going to have zero back pain, even though you have these documented diagnoses. But sometimes what the judges will do is say, yes, you do have back pain, but it's not to the severity and the persistence that you're alleging, because X, Y, and Z in your record doesn't support that. And so a lot of the times what I'll look to is those forms that people do fill out at the beginning of applications, where, they're kind of describing their functioning. So we do have a video on that adult functioning report, which is why that particular form is so important as well, especially for appeals purposes, because you can kind of use that as a consistency basis and to kind of base your credibility off of as well. It really starts from the beginning. Is this consistent with what you're telling your doctors as well? and what shows up in your medical record. So that's really the second most common thing that I see. And almost in every single case, Peter, we're arguing that the judge, if he or she denied your case, that they did not give proper reasons for disregarding your symptom testimony.
Yeah. And the other thing too, I look at, or I would advise clients who maybe not at the federal court level, but who might have this in the back of their mind to set up a good case for themselves, is that don't show up to the hearing and allege a symptom for the first time that you've never told your doctors about, or maybe you've only told your doctors once or twice about and they're buried in the medical records, right? So, and this is an example. For example, if you have headaches and migraine headaches, but you don't consistently kind of tell your doctor what's going on with them, and let's say you maybe mentioned it once in 3 years, don't go to the Social Security judge and say, hey, I have migraine headaches and that disables me, because that will be easy to discredit that type of symptom testimony. What's the third thing and let's just stop at 3 because we got a lot to talk about. So what's the third thing that you maybe evaluate at the appeals council level on if we should take this case to United States District Court?
Sure. So a third thing that I look at has to do with actually the second step of what's called the sequential evaluation. And there's those 5 steps. I'm sure you talked about it in previous videos before. But basically, Social Security has this 5-step kind of list of how they find you disabled. And the second step is actually after going through, are you performing substantial gainful activity? They look to whether you have an impairment that's severe enough and lasts at least 12 months consecutively to actually deem that you do have a disability. And so if a administrative law judge actually stops at level 2 of the sequential evaluation and says, okay, I find that you do have, degenerative disc disease, you do have migraines, but then decides that, even though you're alleging some mental health impairments as well, such as anxiety or depression, I don't find that those are persuasive because there's not enough in your record showing that. That's one thing I can appeal to a federal court level as well. In that, the judge has to properly explain why they didn't think your anxiety or depression was severe. So they kind of have to go through a similar type of analysis as they do with the medical opinions and as well as the symptom testimony and saying, internally, is this supported? And then as well, is it consistent with your medical record that actually you don't have a severe impairment of what you're alleging?
Right. I think when we talk about the kind of these things that you're looking for, what I really want to make it clear to the audience, and because we talked about, a doctor's opinion, and I said it's really important to get it in there. We talked about credibility, getting your symptoms on the record, and then we talked about, maybe the judge incorrectly at step 2, especially in finding a certain diagnosis non-severe, right? What I also want to say is that even if you do have a doctor's opinion or you're getting everything on the record, if a judge properly discredits it within their ALJ written decision, and some of those decisions are 24 pages long, or give or take, if they really go through and properly discredit it, even though we may strongly disagree with the judge's opinion, and we strongly think and believe our client is disabled, there may not be enough legal error to pursue the case in federal court.
Right.
In that case, we have to kind of say, hey, look, let's look at other options, maybe start over, or maybe, refer you to another attorney sometimes, even for a second opinion. And that brings me to this question, and because in the cases that you evaluate, because we believe, like when we go to hearing, that all our clients are disabled. We're not trying to make arguments for, able-bodied people to be disabled. what percentage, like how many, cases do we take to United States District Court? I know the answer. I wanted to make sure you knew the answer because I know you know. But go ahead.
It's very few, Peter. It's about maybe 10% of our cases, and that's because our hearings team does very well, and we do not actually have a lot of appeals to the appeals council, because you do have the highest chance of success, just statistically at the hearing level. So yeah, kind of across the board nationally too. I'd say about with a lot of disability firms, it's a lower percentage of cases that actually do go to federal court. And that's kind of based on exactly what you're saying. There can be kind of some disagreements with the administrative law judge on why they decided that you didn't have a disability. But again, if they provided a lot of explanation and analysis on why they didn't think, this certain disability was severe, or why this medical opinion was persuasive, then that might not constitute a legal error that is appealable. So that's something that, is really hard, and really depends on how much evidence you do have in your file against what the actual ALJ is saying.
Right. And at a federal court level, and we're going to talk about fees and how lawyers get paid, but there's a ton of work that goes into representing folks at the federal court level. And so let's talk about that next. So let's say we decide to take a client on. We internally as a firm, and I know how a couple other law firms do it, but internally as our firm, we close the client's case at the administrative level. And then what we do is if the client wants, and we want to do it, we will re-engage services with the client. And we have this short window. We have like 65 days to file it. So a lot of times we're trying to do a ton of work evaluating, and then let's say, okay, let's engage. There's a couple of things we do though before we can, let's say we say yes, this would be a really good case to take to the United States District Court. The next step is what? We do a quick sort of background check on the client for one big reason. And if you could kind of talk to us about what we look for.
Sure. So one of the big things other